also joining us this afternoon is former presidential spokesman Harry Roque. Sir, magandang hapon and thank you for joining us today.
Magandang hapon at karakanan mo po.
Okay.
First things first, where are you, attorney?
I'm in Austria, Vienna, Austria.
Oh, so bumalik na po kayo doon.
Yes.
Because your asylum application is being handled there, correct?
Yes, it is. According to the Dublin rules, since Vienna, Austria issued my visa, it is Vienna, Austria that must process my asylum application.
Has there been any update on the status of your application?
Well, it's still pending. I had my initial interview. They tell me that there's going to be a second interview.
So, nagka-initial interview na po kayo. And then after the second interview, is that it? That's done?
Yes, there's going to be a decision.
And what's the timetable, sir?
Attorney?
Ano po, Ma'am Ami, again?
How soon kaya yon yung timeline niya? Normally?
Well, they told me that there's going to be a second interview pa, no? So I don't think any decision is forthcoming in the near future until after the second interview.
Pero your passport has been cancelled, no?
I don't think so. I just confirmed that my passport is still valid because I filed a motion for reconsideration, no? That I cannot be a fugitive from justice given that I have invoked my right to seek asylum, and it's in the UDHR, Universal Declaration of Human Rights, that everyone has a right to seek asylum.
So you're free to move around Europe sa ngayon?
I'm free
Or
to move
anywhere
around.
else?
Yes. And even the red alert notice, no, they attempted, but I think I frustrated them. I got an answer from the Interpol that they have accepted my petition to delist me on the basis that as an asylum seeker, EU regulations prohibit that I be put in the alert notice.
I know that you filed an opposition to that Interpol Red Notice, but when you say it was accepted, does that mean they merely accepted the opposition, or they decided, okay, you're right? Which one is it?
They accepted the opposition and asked that I submit English translations of proof that I have sought asylum in both the Netherlands and in Austria.
Okay, so pending a decision pa doon. They haven't decided on it.
But so far, I have confirmed, I have conferred regularly with Austrian authorities that I have not in the red alert notice.
So that's already formal, sir? That's already formal that you are already delisted from the red notice? That's
I don't know if I'm delisted, but I can confirm I am not in the red alert notice.
Hindi pa yata. I think the Interpol still has to decide on the opposition. That's why he's being asked to submit an English translation of his documents.
No, but as I said, I have conferred with the Austrian police, and they have told me that I am not in the red alert notice.
Attorney, you're monitoring, of course, what's happening dun sa trial ni former President Duterte, no? Anong tingin mo sa latest developments?
Well, of course, we're sad, no? Because the president has spent almost a year behind bars at wala pang finding na may probable cause. Because alam naman natin, na pagkakaiba sa ICC is that the determination of probable cause, dito pa lang yan sa confirmation of charges. Sa Pilipinas, hindi dapat nakulong si Tatay Digong nang wala pang probable cause. No? Dito sa ICC kasi, good grounds lang ang basis for warrant of arrest. At ang malungkot, ang pagbalanse doon sa mababaw na ebidensyang hinihingi para sa warrant of arrest yung dapat yung tinatawag na interim release na pinagkait din kay Tatay Digong. So naging biktima si Tatay Digong for all intents and purposes ng arbitrary arrest dahil nga binabalanse yan ng ICC. Merong warrant of arrest pero dapat merong interim release. Pero dito, wala pang probable cause, wala ring interim release.
Any chance of you joining the legal team?
Well, I will announce for the first time that actually it was the prosecutor that objected to my entry as a member of the legal defense team. No? At that time, they were saying that I was facing a warrant of arrest, and I clarified that it wasn't a warrant of arrest, it was a congressional contempt order. No? But in any case, I did not want that the very first salvo for the hearing of Tatay Digong would be centered on me, and therefore, I deferred really to the decision of the family na ayusin ko muna yung aking asylum. But for the first time, I'm announcing that really it was really the prosecutor that objected to my entry of appearance. No? They have sent a formal communication that they would object, and we did not want that the very first controversy on Tatay's case would be on my entry as legal counsel.
So,
Pero, sir,
so it was the prosecutor and not Vice President Sara Duterte who kept you out of the legal team. Was this the old prosecutor, Karim Khan, or the new one?
Yes, it was Karim Khan.
Okay. Go ahead.
Pero sir, does it come as a surprise to you that yung determination of probable cause only comes at this particular point with the confirmation of charges? Kasi that's the impression I got kanina na parang well, we had to accept it reluctantly because that's the way it is with the ICC. But we knew from the very start when we joined the Rome Statute, signed on the Rome Statute, I suppose, not unless things have changed since then.
Well, alam nyo, it wasn't a surprise because that's what's provided in the Rome Statute. What is surprising is that the ICC deviated from the practice of other international tribunals, such as the Tribunal for the Former Yugoslavia and the Rwanda Tribunal. In those two earlier tribunals, it was almost automatic that anyone issued the warrant of arrest is given an interim release, no? Because in the first place, mababaw nga yung ebidensya in order to issue a warrant of arrest. So to be fair and to respect the right of the accused to presumption of innocence and the right to liberty, the earlier tribunals almost always granted interim release. So dito lang talaga sa ICC na nabago yung practice na maski mababaw ang ebidensya for warrant of arrest, pinagkait ang interim release. And in fairness, it's not just Tatay Digong, it's all other accused of court crimes that the ICC has refused to issue interim release.
Pero sir, for example, in the case of Slobodan Milosevic, was he also given interim release after
hindi.
the warrant was issued against him?
But that's why I said almost always, because not everyone. But
Parang
Milosevic died in jail. He was also not given an interim release, but almost everyone else was given interim release.
I mean, they've already explained before that the bar for interim release, if it's crimes against humanity, is very, very high. There are very specific grounds for that.
No, I don't think so, because it was intended to achieve some sort of fairness, no? That it would enable international tribunals to proceed because they would have jurisdiction over the person of the accused, but at the same time, because there still was not probable cause, then they should be given interim release.
Okay, sir. Well,
Attorney, kung-
baka you have
kumusta
numbers. Baka you have numbers to tell us. For example, kasi you did say na most of the other tribunals have in the past almost always given interim releases to the
Yes.
other accused.
Yes. So-
I don't think that's not what the
That's
other.
a fact. That's a fact, no? And I can come up with numbers. It's just that I don't have it now, no? But I have reviewed, and it's almost always that they gave
Not-
interim release. And I'm a member also of the Rwanda Tribunal. It was almost all of them accused of genocide in Rwanda. They were allowed to go home to Rwanda, and they were only expected to attend the hearings whenever there was notice to them.
Were they the same charges of crimes against humanity?
Well, in the case of Rwanda, it was worse. It was for genocide.
Because I think the other ICC, the other lawyers that we've spoken to that know the ins and outs of the ICC say that yun nga, it's a very high bar because it's crimes against humanity. And
That's
in order-
that's what I said earlier, no? The ICC has deviated from the practice of earlier international tribunals because in the earlier international tribunals on Yugoslavia and Rwanda, they were almost always given interim release, but not in the ICC.
Okay, sir. It'll be interesting to see the numbers, sir, when you have them. Kasi
yeah.
a quick and dirty search lang, of course, it doesn't give me numbers as well, says that it's relatively uncommon
Correct.
to be granted interim release by international tribunals. Of course, no numbers here then.
No,
So
in the
that's why
ICC. That's
why
really the
it'll be good
practice
to
in
see
the
the numbers.
ICC.
Okay.
But yun nga, we don't think, we have not heard of any cases where the accused has been granted interim release if it's a very serious charge of, for instance, high crimes against humanity. But let's move on.
I'm not surprised because we're not studying the matter.
We're not studying the matter, we are studying the matter.
No, I'm not surprised that you don't know about the incidents of interim release as issued by Yugoslavia and Rwanda tribunals.
Sir, the interim release was very rare in the case of Rwanda. The judges
No,
generally
that's
considered
not true.
the flight risk too high.
That's not true. As a matter of practice and as a matter of fairness, because of the very low threshold of evidence in the earlier tribunals, I can speak with authority that almost always they granted interim release. It's only here in the ICC now that they have not been following this practice, which, of course, raises the question of fairness, because we all know that
no, no,
good
no.
grounds
I don't
is a
think
very low threshold of evidence.
I don't think they've deviated only now. I think it's been the practice even before. As I said, we've spoken to a lot of ICC related lawyers on this, and they have said even in the past. I know what you're trying to say.
You're
which is
insisting on ICC practice, and I have conceded in the ICC, it has not been the practice. What I'm saying is in the earlier tribunals, and of course, the precursor for the rules of the ICC are the earlier tribunals, it was almost given, always given.
Anyway, I think we will need to see the data on that.
Exactly, and we'll
begin
speak
with.
to the ICC about it. But in any case, let's move on. The ICC also announced co-perpetrators in Duterte's case on the war on drugs. What did you think about it?
I thought it was unfair because, number one, the ICC had only recently come up with a rule that the service of warrants of arrest will be treated confidentially. No? And number two, there is still a decision forthcoming from the appellate chamber on the issue of jurisdiction. Now, when the issue of jurisdiction first reached the ICC, the voting was 3-2. 3 judges said the court had jurisdiction, 2 judges said there was no more jurisdiction. Now, the issue from jurisdiction, while pending, the parties have submitted their respective observations, but the court asked both parties to submit additional observations, indicating that the court is seriously examining the issue of jurisdiction. No? And I thought it was unfair that the ICC itself breached the rule of confidentiality on warrants of arrest by announcing the co-perpetrators as if to preempt the appellate chamber's decision on whether or not there is in fact jurisdiction. So I think the more prudent thing to do was to honor the confidentiality rule until after the appellate chamber has ruled on the issue of jurisdiction.
To be clear, there are no arrest warrants yet. They were just named as co-perpetrators. We don't even know if there will be arrest warrants at this stage.
It goes without saying that, as the lawyer for President Duterte has said, they themselves have known all along who these co-perpetrators are, but because of the confidentiality, they have kept it to themselves, and they're surprised that it is the ICC itself that broke the rule on confidentiality.
Normally, kapag nag-issue na ng ganyang list of co-perpetrators accused, can we expect arrest warrants from the
Yes,
ICC?
I think so, because as I said, the threshold for arrest warrant is very low, only good grounds.
Yes.
Yes. And I think the issue of the confidentiality has to do with the cooperation of states, because the ICC does not have their own police force. They will have to rely on cooperation of states, and that's why they have this rule now on confidentiality.
O sige. Kumustahin ko naman yung cases in the Philippines. Attorney, kumusta na yon? How are they moving along?
Well, I have a pending petition for review with the Secretary of Justice, which is a prerequisite for judicial review, and this is on the finding of probable cause. So after the DOJ panel of prosecutors ruled that there's probable cause and that there's likelihood of successful prosecution, I filed an appeal with the Prosecutor General, which denied the appeal. And the final step for administrative exhaustion of administrative remedy is the petition for review with the Secretary of Justice, which has been pending forever and ever in the Office of the Secretary of Justice.
Kung sakasakaling if we request an extradition, we cannot request your extradition while your amnesty petition is pending,
Well, they cannot. They can attempt to request extradition, but in the first place, there's no extradition treaty between the Philippines and Austria. So there's no basis to request for extradition. No? Now, what they can hope for is the red alert notice, but EU, the EU is very specific that when a person has an application for asylum, then a red alert notice is not a basis for extradition. It's a decided doctrine.
Is that the non-refoulement principle which you have mentioned in the past?
Yes, it's a non-refoulement principle and a rule of the EU as far as Interpol is
Oh,
concerned.
by the way, sino nagsabi sa atin that the pronunciation pala was non-refuma because it's
Non-refoulement, yes, it is non-refoulement.
Okay, but isn't that the core principle? It's a core principle for international human rights and refugee law, but isn't that only based on political persecution? The government is arguing that
Yeah.
you are facing criminal charges, not political persecution.
That's a decision to be made by Austrian authorities because I believe and I submit that I'm a victim of unjust prosecution because there's absolutely no evidence indicating that I was involved in human trafficking. None of the elements have been shown in the resolution of the public prosecutors. There's not even a complainant against me for human trafficking.
Okay. Alam mo, cambio naman ako ng ano.
Go ahead.
Sige.
Sige, go ahead.
Cambio ako sa lokal na balita. I'm sure you've heard about VP Sara and her announcement. Yeah, you did post
Running
something on
for
social media
president.
kanina. Any idea kung bakit ganito yung timing ni VP Sara for her announcement?
Well, okay, I will be very clear. I have not had the occasion to talk to VP Sara since the announcement. But I'm sure this has to do with the impeachment. Magkakalinawan na tayo kung sino talaga ang pwedeng pagkatiwalaan ni VP Sara. We all know na walang kahit sino, if elections were to be held today, that can defeat Inday Sara in an honest-to-goodness elections. So I think the decision to declare her candidacy now is to give notice to members of Congress and the Senate that she will be a contender for the 2028 elections and that they better watch out. Because kung as usual, sila ay boboto because binili ang kanilang mga boto, think again because this woman will almost certainly become president if honest elections are to be held.
So, I understand what you're saying na kung binili ang boto, this is a reminder to you. But at the same time, the other side of the coin seems to sound like, watch out, kasi kung manalo ito, patay kayong lahat.
It's
Babawian
payback
kayo.
time.
That's also how it sounds.
Well, there's nothing wrong with that because that's politics. We all know na may mga malalakas na kandidato, may mga mahihinang kandidato, at kung sila ay magpapabili ng kanilang mga boto, think again because the politician's concern is always staying in office, and when you're enemy of the soon-to-be president, that's not good politics.
You said you haven't spoken to her since the announcement, but when was the last time you spoke to her, and are you going to be part of this, her team?
Well, I don't know how I can be part of active campaigning in the Philippines while I'm still here, but I certainly still have a voice, and I've been endorsing Sara Duterte to be the alternative to Marcos, whether be it for 2028 or even now.
Wala ka bang balak bumalik in the Philippines? Kasi yun ang sinasabi
I'm
ng mga
awaiting
kanya, that you
actually.
should face the charges.
Ami, I am facing the charges because of the petition for
Yes.
review. I am complying with the exhaustion of administrative remedies, and I will avail of judicial remedies, assuming, of course, the Secretary of Justice finally acts on the petition for review.
The government says you are a fugitive of justice and also a fake news peddler, especially off the back of what you posted recently, suggesting that President Marcos is seriously ill and that he had a colostomy bag.
First, I am not a fugitive from justice. I am an asylum seeker, which is recognized as a fundamental human rights, particularly in the Universal Declaration of Human Rights. Secondly, I never claimed that the president was seriously ill. I merely asked the question, ano ba itong bag na nakikita ko na nasa loob ng barong ni Marcos Jr., Is it a colostomy bag? Because the last time I saw a colostomy bag, it was then Mayor Osmeña of Cebu City that had it, And it looked very similar to what Mayor Osmeña had. So mine was an honest-to-goodness question because in the Constitution, it states that the people have a right to information, particularly when the president has a serious illness. So it was in fact a question and an appeal to Anteclair to tell the truth kung ano ba yung mukhang colostomy bag na nasa loob ng barong ni Marcos Jr. I don't think that is fake news. It's an honest-to-goodness question and the people deserve an honest answer.
But it wasn't a colostomy bag, and the fact that I mean, you're a lawyer, so you know this. Insinuating something is just as bad, right? There's malice in there.
No, I wasn't insinuating. It was a straightforward question. There was a question mark. And in fact, I even said, I'm asking Anteclair.
Okay, we want to talk about We want to talk about this more, but we've run out of time. But thanks for joining us and talking to us today, former presidential spokesperson, Attorney Harry Roque.
Thank you very much.
Thanks, attorney.
Thank you, sir.
Bye-bye.